All right, diving in today, and we're going deep on something that's, well, pretty fundamental to how our legal system works here in England. Legal precedent.
Yeah.
You sent over some really fascinating stuff, excerpts from Legal Method, and honestly, the more I looked at it, the more I thought we really need to unpack this. Like how do courts actually use past decisions to figure out the cases they're dealing with right now?
Yeah, absolutely. This whole idea of past judgments informing the current ones, that's like the cornerstone of common law, right? There's a lot to unpack there. So I think our deep dive today is all about pulling out those key insights from your sources and really giving a kind of clear picture of how this whole precedent thing actually functions.
Okay, so at the heart of it, we're talking about binding precedent, right? And what really stood out to me from the material was it's not just a suggestion. It's like all lower courts must follow the decisions of higher courts. And what's even more interesting, some courts, they actually bind themselves, which brings us back to that court hierarchy thing we've talked about before. That structure is super important here, isn't it?
Oh, yeah, for sure. It's like chapter 3 of your text really dives into this, but basically the whole structure of the courts, like who sits above whom, that dictates how binding precedent flows. So let's say the Supreme Court makes a ruling. Well, that creates a precedent that the Court of Appeal, the High Court, all the lower courts, they all have to follow it.
But here's where it gets really interesting, right? There's this inherent tension that the source material points out, and I think it's a really crucial point. On the one hand, you've got this need for predictability in the law. Like people need to have some sort of reasonable idea of what the legal consequences of their actions are going to be. That's the rule of law in action, right?
Exactly. And pages 61 and 71, I think they really hit this head on. This idea of certainty and stability in the law, that's like a core part of the rule of law. If legal outcomes were just constantly changing, it would be almost impossible for people to make informed decisions, plan for the future, do business.
Total chaos, basically. But then, on the flip side, you've got this concept of the separation of powers. And that gives judges the independence to interpret the law based on the specific facts of each case that comes before them. So that implies, well, a degree of flexibility, right? Can't just be this robotic application of, old rules to every new situation that pops up, can it?
Absolutely not. I think the real strength and, the complexity of the common law system, it lies in that balance. Judges, they're not just expected to be like legal robots. They need to be able to adapt the law to new circumstances, evolving societal norms. So yeah, this tension between predictability and flexibility, it's really at the heart of understanding how precedent works.
And it seems like this idea of bindingness, it's not always as cut and dry as it might sound on the surface, The material quotes Carlton Kemp Allen as saying that, and this is a great quote, that certainty is the very last quality you could attribute to precedent. That's a pretty strong statement, and it suggests to me that there's a lot more nuance going on here than simply, following a set of rules.
Oh, for sure. I mean, Allen's observation from 51 LQR 333, that's like cutting to the chase. Even in a system that's built around following past decisions, there's often a lot of room for interpretation. What did those past decisions actually mean? How do they apply to these brand new situations? A lot of legal argument, that's exactly what it revolves around.
Right. So it's not like you've got this universal legal playbook that just has all the answers laid out nice and neat for every situation.
Mm-hmm.
And to kind of broaden our perspective a bit, I thought it'd be interesting to touch on how the European Court of Justice deals with precedent, because the material you sent over actually touches on that too. So, a little comparative look to add some extra insight.
Yeah, I think that comparative angle, it's super valuable, It helps us understand that while the English system of precedent has been very influential, it's not the only way to approach the whole idea of using past judicial decisions.
All right, so let's get into the specifics here. The material talks about wide and narrow views of precedent. What exactly do we mean by that?
So I think the wide view of precedent, it's essentially that general principle that cases with similar facts, they should be decided similarly. And that's grounded in some really basic ideas, fairness, making sure the law is applied consistently, efficiency for the legal system. You don't need to keep relitigating the same points over and over again. And then there's this idea of judicial comity, like mutual respect among judges, everyone's working together kind of thing.
Okay, so it's about fostering a consistent and, efficient legal landscape and doing it with this kind of like we're all on the same team mentality within the judiciary. That makes sense. But then there's the narrow view. What's that all about?
Yeah, the narrow view, that's where it gets a bit more hardcore. It says that courts aren't just encouraged to follow earlier decisions, they're actually obligated. And as your source points out, this strict, binding kind of precedent, it's pretty unique to English law and the common law systems that came from it. It's a much, much stricter obligation than just that general idea of consistency.
Okay, so wide view is like a preference for consistency. Narrow view is, you got to do this, it's the law.
Got it.
Now, the material, it uses some really interesting case studies to show how this works in practice. And I love the one about the tax-free annuities in World War II. Like, what a crazy set of circumstances, right? Tell us about that.
Yeah, this is a classic example of how, unexpected events can really test even the most seemingly well-established legal principles. So picture this. You've got people in the years leading up to the war. They're making their wills, right? And they're setting up annuities for their beneficiaries, which are basically annual income payments. And they specify that these annuities, they should be tax-free.
Sounds like a nice gesture. But knowing how much income tax changed during the war, I think I can guess where this is going.
Right. And as income tax rates went up, up, up during the war, Parliament had to do something. So they brought in the Finance Act of 1941. And this act, it said that for annuities that were made before the 3rd of September 1939, the beneficiaries would only be exempt from a very small part of the tax increase, like specifically the first 5 shillings and 6 pence in the pound. So basically, they were going to have to pay the higher tax on most of their annuity income.
So the government steps in to kind of adjust these pre-war financial arrangements to reflect the new reality, Totally understandable. But as the source points out, there was this huge legal question that came up. If the will itself was written before that date, September 3rd, 1939, but the person making the will, the testator, didn't actually die until after, when exactly was the provision made?
Yeah, that's the million-dollar question, right? Was it considered made when the will was written, reflecting what the testator wanted at that time? Or was it only made when the testator died? Because that's when the will actually becomes legally effective.
Two very different interpretations.
Yeah.
And they would have had huge implications for the people who were supposed to get those annuities.
Absolutely. And it led to this really important case, Re-Waring, Westminster Bank v. Audrey and others. This was back in 1942. And the Court of Appeal in this case, they decided that the Finance Act of 1941 did apply. So the annuity payments, they were subject to those higher wartime tax rates.
But then, in 1946, along comes Berkeley v. Berkeley, which went all the way up to the House of Lords. In this case, it dealt with the same legal question, but a completely different will. What did the highest court in the land decide in that one?
Well, they came to the opposite conclusion. They said the provision wasn't made until the testator died. And if that death happened after September 3rd, 1939, like it did in Berkeley, then the 1941 Act didn't apply. So in Berkeley, the annuitant got the full tax-free benefit, just like it said in the will.
So the highest court contradicts the Court of Appeal on the exact same point of law. That really throws a wrench into this idea of a perfectly consistent legal system, doesn't it?
It definitely shows that things aren't always simple, and that even seemingly settled legal questions can be reinterpreted, and the timing of things, that can be hugely important.
And of course, it doesn't end there, does it? There's a second Re-Waring case in 1948. What happened in that one?
Right. So the second Re-Waring case, it's about the same will as the first one back in 42, but now it's 1948, the war is over, and crucially, both of the annuitants are parties to this case. So now the court has to deal with its own earlier decision, the one from the Court of Appeal, and then the House of Lords decision in Berkeley, which directly contradicts it.
Yeah, how do you even begin to untangle that legal mess?
Well, the court applied this principle called res judicata to the annuitant who'd been involved in that first Re-Waring case. Res judicata, it basically means that if a court's already made a decision about something, the same parties can't just keep bringing it back to court to try and get a different outcome. So because the court had already decided about the 1941 Act and her annuity, she was stuck with that decision, even though the House of Lords had since said something different.
That seems a bit rough. Like, one person gets one outcome, and another person in the exact same situation gets the opposite, just because of when their case went to court.
It does seem unfair, yeah. It shows that the legal system's need for finality, it can sometimes override, what we now see as the correct legal principle. But the other annuitant in this case, the one who hadn't been part of that first Re-Waring case, she did get the benefit of the House of Lords decision in Berkeley. So for her, normal precedent applied, and her annuity was completely tax-free.
A real tale of two annuitants, then. Each one bound by a different precedent because of the specifics of their legal journey. It really shows how these doctrines can play out in the real world. Now, let's talk about this idea of retrospectivity. The material explains that when courts change the law through precedent, It usually applies to things that have already happened. That seems, I don't know, a bit potentially problematic, doesn't it?
It can be, yeah. Like we saw with those Rewaring and Berkeley cases, the Berkeley decision, it essentially changed the law for events that had happened before the ruling, and that's usually how it works. The law, as declared by the court, it's treated as if it was always that way.
So someone could have done something that was perfectly legal at the time, and then a later court decision could make it illegal. Or the other way around. That doesn't really fit with the rule of law, does it? Like, how are people supposed to know where they stand if the law can change retroactively?
Yeah, that's a really good point. It definitely creates some tension there. The source material talks about this conflict, and it gives another great example. The whole thing about overturning the marital rape exemption.
Yes. That old idea that a husband couldn't be guilty of raping his wife. Take us through how precedent played a role in getting rid of that.
So this idea, it goes all the way back to Sir Matthew Hale hundreds of years ago, and it was a big part of the law for a long time. But then in 1991, in RVR, rape, marital exemption, the House of Lords said, no, a husband can be guilty of raping his wife. They overturned that old common law principle, and then this decision was used in later cases like RVW.
And this wasn't just about future cases, right? These cases involved prosecutions for things that had happened when that old rule was still in place. That's a pretty major retrospective application, especially when you're talking about criminal law.
It is, definitely. And the material even mentions the argument that this could go against Article 7 of the European Convention on Human Rights. That article, it says that you can't be found guilty of a crime for something that wasn't a crime when you did it.
So the argument was that these men were being punished for something that wasn't illegal at the time.
Exactly. But the European Court of Human Rights in SWV United Kingdom and CRV United Kingdom, they said there was no breach of Article 7. They argued that even if these men had gotten legal advice at the time, they could have reasonably foreseen that the law would change because, society's understanding of marriage and equality, that had been changing a lot. And they also emphasized how serious rape is, it's degrading and harmful. So they said the English court's decisions weren't totally out of line with the purpose of Article 7, which is to stop people from being prosecuted unfairly.
So foreseeability, that was a big part of why the European Court upheld the retrospective application. But then the material brings up RVC in 2004. That was an appeal against a marital rape conviction from 1970, and the appeal actually failed. They argued that just because something was foreseeable in the 90s doesn't mean it was foreseeable back in 1970.
Yeah, and the Court of Appeal in that case, RVC, they didn't buy that argument. They said that if you look at how the law had been developing since Hale's time, even back in 1970, you could have seen this change coming. The source does offer a bit of a cynical take, though, pointing out that the appellant in that case, he was facing some other pretty serious charges, and that might have influenced the court's decision.
Interesting point. So retrospectivity is usually how it works when precedent changes, but are there ever times when courts hesitate to overturn a precedent because of how it might affect past events?
Yes, there are. Prudential Assurance Co. Ltd v. London Residuary Body in 1992 is a good example. The House of Lords in this case, they really didn't want to follow this old, very technical land law principle. Lord Brown Wilkinson, he even said that if they could have changed the law just for future cases, they would have. But changing centuries-old precedent in something as fundamental as land law, they thought that would just cause too much chaos. Like, imagine all the property titles that would be thrown into question.
So they decided it was better to stick with the old rule, even though they didn't like it, and just hope that the Law Commission would come up with a fix that wouldn't apply retrospectively.
Exactly. It shows that even though retrospectivity is usually how things work, courts are aware of the potential for disruption, especially in areas of law where people rely on things being settled.
Okay, this brings us to prospective overruling then. This is the idea that a court could say, all right, here's a new legal rule, but it only applies to future cases, not to this case or anything that's already happened. Given all the problems with retrospectivity, why isn't this the usual way things are done?
Well, the main objection to prospective overruling, it all comes down to the separation of powers. The argument is that if courts start making new rules that don't even affect the case they're deciding, they're essentially acting like legislators, and that's supposed to be Parliament's job.
Right. The classic view is that courts interpret and apply existing law, while Parliament is the one who makes new laws or changes old ones. Prospective overruling seems like it muddies the waters a bit.
Yeah, for sure. But the material also points out that, well, you could argue that anytime a court sets a new precedent, there's a bit of a legislative element to it, right? Because those new interpretations, they're going to shape how the law is applied in the future. Plus, international courts, like the European Court of Human Rights, they often work with a degree of prospectivity. And even the ECJ can sometimes limit how far back its decisions apply.
So this separation of powers argument, it's not a hard and fast rule everywhere. What about practical reasons people have given against prospective overruling?
One big practical concern is, well, why would anyone bother taking a case to court if they wouldn't benefit from a change in the law? Going to court, it takes time, it costs money, it's a lot of effort. The material suggests that maybe big organizations that are always in and out of court, they might be interested in pushing for changes in the law, even if they don't win a particular case. But for the average person who just wants justice in their own situation, why would they go through all that just to help out people in the future?
They'd be like legal reformers without getting anything out of it themselves. Not exactly the most motivating thing.
No, not really. But the Supreme Court in Respectrum Plus, they did say that there could be situations where prospective overruling is necessary, to administer justice fairly and in accordance with the law. So that suggests that maybe in very extreme cases where applying a new rule retrospectively would be super unfair, they might consider prospective overruling.
So the doors open a crack, but only a tiny crack for these really rare and extreme situations.
Yeah, that's about it. But the material also highlights a big area of doubt, especially when it comes to interpreting laws passed by Parliament. Lord Scott and Lord Steyn, they had this strong view that if a court figures out the real meaning of a law but then refuses to apply it retrospectively, that would be going against the Bill of Rights. The Bill of Rights says the Crown can't just suspend laws without Parliament's okay. Now, the majority of the court in Respectrum Plus, they didn't agree with this particular concern, but it does suggest that there might be constitutional limits on how much prospective overruling can be used, especially when dealing with what Parliament has said.
So the debate around prospective overruling, it's not over yet, and it involves some pretty fundamental ideas about how our legal system is supposed to work. Now let's switch gears a bit. The material asks this really interesting question. Are court decisions actually the law? Or are they just evidence of what the law is? Sounds like we're getting into deep philosophical waters here.
It is a question with a lot of philosophical baggage, yeah. But, like you said, it also has practical implications for how we understand the system. On one hand, it might seem obvious that court decisions do make law, right? The material quotes Lord Dunning. He basically said, if there's no law on something, we'll make some. And Lord Edmund Davies, he even said straight out that judges inevitably act as legislators.
So from that perspective, courts aren't just passively applying rules that already exist. They're actively shaping the law through what they say. But if that's the case, why is there even an argument about it? What's the other side of this debate?
Well, the main constitutional concern is that judges, they're not elected, right? They don't have that same democratic legitimacy as Parliament. And then, like we talked about earlier, judicial decisions usually apply retrospectively, which most new laws don't. Plus, if court decisions are the law, why are only certain courts bound by them? It's like there's a hierarchy even above the law for those courts that aren't bound.
Yeah, good points about democratic legitimacy and the potential for unequal treatment under the law. So, to try and address these concerns, people came up with a declaratory theory, right?
Yeah.
The idea that judges aren't making new law, they're just saying what the law has always been, maybe clarifying it for new situations.
Exactly. Way back in the 18th century, Sir Matthew Hale, he was a famous legal scholar, he said that court decisions, they have great weight and authority in expounding, declaring, and publishing what the law is. But they don't make a law properly so called.
But the source also throws in this really blunt critique of this theory from John Austin, another legal heavyweight. He called it, and I love this, a childish fiction. He clearly wasn't buying the idea that judges were just passively declaring what the law already was.
Nope, not at all. And he wasn't the only one. Even in the late 1800s, Lord Esher, he was a prominent judge, he still believed that judges don't make law. He said their job is to apply the existing legal principles to new facts and circumstances. And people who support this declaratory theory, they often compare it to witnesses giving evidence in a trial. Like different witnesses might have slightly different accounts of the same event, different judges might have slightly different interpretations of the law.
But the material points out some pretty big holes in that argument. Like we've been talking about this whole time, how earlier court decisions really do dictate what happens in later cases. That doesn't sound like just considering evidence.
Right. And if these common law rules only exist when a judge says they do, and if those rules can change over time as judges' interpretations change, how can you say that they exist independently of the judges? Like, they're not objective facts that witnesses can just talk about. The material basically concludes that while this whole evidence argument might sound good in theory, it doesn't really hold up when you look at how precedent actually works. But it does say that the fact that Parliament can overrule court decisions, that provides some comfort to those who don't like the idea of judges having so much power.
So this idea that judges are just declaring the law, maybe it sounds nice, but the reality is that they play a big role in shaping it, even though they have to work within certain boundaries. Now let's talk about how we figure out what parts of a court decision are actually binding. That's where ratio decidendi and obiter dictum come in, right?
Yes, exactly. The traditional understanding is that not everything a judge says in a judgment is equally important. The ratio decidendi, which is Latin for the reason for the decision, that's the crucial part. It's the principle, the reasoning behind the court's decision. And then there's obiter dictum, often just called dicta, which means things said by the way. That's everything else, the remarks, observations, opinions that weren't essential to the actual decision. So obiter dicta are not binding on future courts.
So it's like we have to go through a judgment and find that core reason for the ruling. But the material makes it sound like this isn't always easy or objective.
No, it's definitely not. It warns against this idea that the ratio is just sitting there in the judgment waiting to be discovered. Formulating the ratio, it's actually a much more dynamic process. It involves interpretation, analysis, choices made by the later court. The material even quotes Salmon, who compared a judicial decision to a point on a graph, and the ratio is like the line that a later court draws through that point. So there's some flexibility in how you determine what that principle is.
So different judges, looking back at the same case, might come up with slightly different ratios depending on how they interpret the original reasoning and the facts of the new case.
That's right. Finding the material facts of the original case, the ones that the court considered important, that's the first step. But then it's up to the later judge to figure out which facts were really material and how broadly that rule should be understood. Lord Halsbury, he said that you always have to understand the language of a judgment in the context of the specific facts of that case. And Carl Llewellyn, he said that a case only really makes sense when you compare it to other cases and look at the bigger picture.
Okay, so how broadly or narrowly we define those material facts, that makes a big difference in whether a case is seen as binding or not. That idea of level of generality, that sounds important, but also maybe a bit subjective. Could you break that down a bit more?
Sure. So when a court's trying to figure out the ratio of an earlier case, they have to decide how broadly to categorize the facts. Llewellyn had this famous example. Imagine a case where a legal principle was applied to a Buick car. A later court might have to decide, does this principle only apply to Buicks, or to all cars, or to all vehicles? The level of abstraction they choose, that's going to determine whether that earlier case is binding in a new case with similar but not identical facts. Lord Reed even admitted that how he'd define the ratio could depend on whether he wanted to make a narrow, specific rule or a broader, more general one.
So it's not just about finding the key facts. It's also about deciding how generally those facts should be applied to other situations. It's more complex than just picking out a sentence from the original judgment.
Definitely. Now, the material brings up something else that's interesting. What happens when courts are split in their decisions? Does that affect precedent?
Yeah. In the old House of Lords, if the judges were split, the lower court's decision would stand, and that House of Lords decision would then be binding on future House of Lords cases. I assume that's still how it works with the Supreme Court.
Yeah.
But the material says things are a bit more complicated with the Court of Appeal.
You're right. There are a few different cases that have dealt with this, and they don't all agree. The Veracruz case that said a split decision in the Court of Appeal doesn't create binding precedent. But then Hart v. Riversdale Mills seemed to say that the House of Lords rule should apply to the Court of Appeal too. But then Galloway v. Galloway seemed to go back to what the Veracruz said. The material points out that these later cases, their authority is a bit shaky because they didn't always properly consider the earlier decisions. The bottom line is, a split decision in the Court of Appeal, it's not likely to create a strong precedent. It's a bit of a legal muddle.
Sounds like it's better to have a clear majority decision if you want to set a solid precedent. The material also talks about how it can be helpful to have multiple opinions in higher court cases.
Right. Lord Upjohn, in Saunders v. Anglia Building Society, he said that comparing the different things the judges say about the law, that can often give you a much clearer understanding of the ratio than just looking at what one judge said. It helps you see the nuances of the reasoning.
But is there always a clear ratio in every case? The material suggests that sometimes the reasoning might be so messy that it's hard to pull out one principle.
Yeah, Lord Dunedin in the Mostyn case, he said that if the ratio of an earlier case isn't clear, later courts shouldn't have to bend over backwards to find one just so they can be bound by it. So if the reasoning's too ambiguous, the decision might be seen as applying only to those very specific facts rather than setting a broader rule.
Okay, so we've found the ratio, the binding part.
Yeah.
What about when courts don't like a precedent, or they think it would be unfair to apply it in a new case? That's where distinguishing comes in, right?
Exactly. Distinguishing, it lets a court say that an earlier case, even though it might seem relevant, doesn't actually apply because the facts are different enough. It's a way to avoid being bound by a precedent without directly saying that the earlier decision was wrong.
Like saying, yeah, that other case, that was about apples, but this one's about oranges. They're both fruit, but they're not the same.
That's a good way to put it. The material also mentions a more specific type of distinguishing, confining a decision to its own facts. This can be a subtler way for a court to say they have doubts about a previous ruling without actually overruling it. Jobling v. Associated Dairies, where the House of Lords didn't follow their earlier decision in Baker v. Willoughby, that's an example. They basically said that Baker v. Willoughby was so fact-specific that it didn't create a general rule.
Clever legal maneuvering. What about when a court thinks a previous decision was just plain wrong, like they missed a crucial law or something? That's per incuriam, right?
Right. Per incuriam, it means through lack of care. It's when a court makes a decision without considering a relevant law or precedent. But there are different opinions on what happens when a decision is per incuriam. Some people think later courts must not follow those decisions because they're flawed. Others think later courts can choose not to follow them, but they don't have to.
So even if a precedent exists, if it was made because of a mistake, later courts can question it. The material mentions Miliangos v. George Frank, textiles here.
Yeah, Lord Simon in that case, he said that per incuriam should be used modestly and with reluctance, which suggests he thought those decisions shouldn't be followed. But the material also says it's not clear whether R.V. Simpson, which took a slightly different view, will be accepted more widely.
And then there's changed circumstances, which the material says is more like a type of distinguishing. What's the difference there?
Changed circumstances, it doesn't actually give a court the power to overrule a precedent. It's more like a reason why they might overrule it if they already have the power to do so. The idea is that society or the economy or something has changed so much since that earlier decision that the precedent isn't relevant anymore.
Like saying the world's moved on and the old rule doesn't work anymore.
Exactly. Now, earlier we touched on obiter dictum not being binding. Can you remind us why that is?
Well, if something a judge said wasn't crucial to the decision, it probably didn't get the same level of argument and consideration as the main issue in the case.
Right. Dicta, they're statements that fall outside the ratio. They might be interesting, they might be persuasive, but they're not binding because the court might not have heard all the arguments on that point or thought about it as carefully.
So a judge might have some thoughts on a related legal issue, but those thoughts don't create a binding precedent. The material also mentioned the Attorney General's reference procedure under Section 36 of the Criminal Justice Act, 1972, and how it's hard to figure out a jury's ratio. That seems unusual.
It is pretty unique. So under this procedure, the Attorney General can ask the Court of Appeal for an opinion on a point of law that came up in a criminal case, even if the defendant isn't appealing their conviction. But because juries don't give reasons for their verdicts, it's impossible to know the ratio behind their decision.
So the Court of Appeal's opinion, it wouldn't be binding on other courts because it's not based on a clear ratio from the original trial. That makes sense. Okay, let's get into how precedent works in terms of the court structure. We talked about higher courts binding lower courts. That's the vertical side of things. But then there's also the horizontal side, courts binding themselves. What's the deal with that?
All right, so starting with the Court of Appeal, they're generally bound by the Supreme Court, obviously. But there have been a few rare cases where they've departed from Supreme Court precedent, usually when they felt it was absolutely necessary to prevent a serious injustice.
So they could bend the rules a bit if justice demands it. What about the Court of Appeal binding itself? And what about divisional?